If you're a content creator, receiving a DMCA takedown can be somewhat of a panic-inducing process. Today in this video, I want to do a step-by-step guide and walk you through filing a DMCA counter notice and getting your content back online. DMCA takedown notices can be stressful, but counter notices can get your content back online if wrongly accused. By filing a DMCA counter notice, you can challenge the validity of the takedown and potentially have your content restored. In today's video, I will walk you through the steps of filing a counter notice. Let's start with understanding the DMCA and your rights. Before you file a counter notice, it is essential to understand the Digital Millennium Copyright Act and your rights as a content creator. The DMCA provides a safe harbor for online service providers, also known as ISPs, Internet Service Providers, who host user-generated content, protecting them from liability for copyright infringement committed by their users. Sites like YouTube, Etsy, Instagram, and Twitch. These are examples of online service providers that host a lot of content creators' content. However, it also provides a mechanism for copyright owners to request the removal of infringing content through a DMCA takedown notice. As a content creator, you can challenge the validity of a takedown notice by filing a counter notice. You can learn more about what a DMCA takedown request is by going to a previous blog and video I've covered on takedown notices on www.drishtilaw.com, or you can go to any of my social media channels, specifically my YouTube channel, Visualize Your Brand. Now, next we're going to move on to reviewing the takedown notice itself. The first step in filing a valid DMCA counter notice is to carefully review the DMCA notice you received and identifying the specific content that is claimed as infringing. This may include text, images, videos, or other types of content. It's essential to be as specific as possible in identifying the claimed infringing content, including the URLs or additional identifying information. You should do the best you can in describing the content that has been alleged by the claimant to be copyright infringement. Remember that if you file a counter notice for that content that is not infringing, you could be subject to legal action. Next, we're going to start drafting a counter notice that includes specific information. Once you have identified the content claimed as infringing, it's time to draft your counter notice. Your counter notice should include specific information such as your name, address, and contact information, as well as a statement that you have a good faith belief that the content in question was removed or disabled due to a mistake or misidentification, or that you had a reason, basically, to be using the content. You should include a statement that you consent to the jurisdiction of the federal court in which you are located and that you will accept service of process from the person who filed the original takedown notice or their agent. Finally, you should sign the counter notice under penalty of perjury, certifying that the information you have provided is accurate and that you are authorized to act on behalf of the owner of the content in question. And finally, we're going to submit the counter notice to the designated agent. Once you've drafted your DMCA counter notice, it is time to submit it to the designated agent of the online service provider. This is easily searchable. Every online service provider provides access to their designated DMCA agents. This information should be included in the takedown notice you receive. So you can typically submit your counter notice via email or regular mail. Be sure to keep a copy of your counter notice for your records. After submitting the counter notice, you must wait for the copyright owner to respond. They have about 10 to 14 business days to notify the online service provider that they filed a lawsuit against you and to keep your content offline. The internet service provider may restore your content if they do not take any further action. However, if the copyright owner files a lawsuit, you must seek legal counsel to defend yourself. It's important to note that a false DMCA counter notice can result in legal consequences, so ensure that you have a valid reason for disputing the takedown notice. Submitting a DMCA counter notice can be a complicated process and could expose the content creator to legal action from the complainant. It is advisable to seek the guidance of an intellectual property attorney when filing a counter notice so you can do the right checklist when you're drafting that counter notice. If you received a DMCA takedown notice and need help determining your next course of action, please feel free to schedule an introductory call with the law firm by calling 773-234-1139 or going to www.drishtilaw.com. As always, this is Sahil Malhotra. Thank you for watching.